Good morning, afternoon, good evening, good tomorrow to everybody. One wonderful thing about being worldwide is that you all are everywhere, and we're so happy that you could join us today. I am president-elect of Every Cat Health Foundation, formerly the Win Feline Foundation. Some of you probably know us by that name. We are really, really delighted that you are joining us. I am assuming that either you have donated to Win or Every Cat, or you're thinking about donating now, or even planning to donate in the future. And let me tell you why that's so important. You know, for many years, cats have always played second fiddle, so to speak, to dogs. Dogs have been the big dogs. They've had the support through donations, money for research, and so a lot of health issues in dogs have been studied over the years. Not so much in cats, but you know, as you probably all have witnessed, cats are coming into their own. And now we have, with all of that interest in cats, we have researchers that are interested in cats. We have researchers that want to work on feline health issues. The problem is, of course, is that we can only do that, or they can only do that, when we can get donations from you all to support the cats. And to give you a good example, we had our largest grant cycle just a couple weeks ago, and we had a record-breaking 67 proposals came to us, probably pushing $2 million worth of requests for funding for wonderful, wonderful projects that you know, most of which would have probably been certainly worthy of funding, but we couldn't do that. We ended up, I believe, funding something in the neighborhood of maybe 13 or 14 of those 67 projects. So a lot of good research on health issues of our cats unfortunately had to stay on the table. So we hope that you all will help us help the cats over the years, and donate as you can or will. I'd like to introduce our guest speaker for today, and that's Mr. George Eigenhauser. And some of you probably know George. George has been on the Win, or now Every Cat board, for more than 17 years, but he's also been involved as legislative coordinator and member of the CFA board for over 22 years. You know, George has had a lot of experience in this particular topic in wills and trusts, estate planning, and we're going to hear from him today how we can be thinking small, big, now and later. So the what, when, and how of planned giving, George, it's all yours.
Okay, if we could roll to the next slide, please. Or not. Just to let you know, although I am a lawyer, I am not your lawyer, so I have to start out with this legal disclaimer. Anything provided in this webinar is just informational, it's educational. I am not your attorney. If you have advice that you need from an attorney, you have to retain an attorney, and do not rely on any of the information in this without consulting with your tax advisor. So, what the heck is planned giving and why do I care? One of the things people often mistakenly believe is that planned giving means estate planning. And that's certainly a part of planned giving. But planned giving starts at day one. It just simply means thinking through your donations and your pattern of donations in order to maximize your objectives. What are your objectives? What are you trying to do with planned giving? Well, first, you're trying to tailor your giving to your means and your lifestyle. For some people, that means periodic donations. For some people, that means estate donations. For some, that means a payroll deduction every month. You do this in order to maximize the benefit to the charity and the causes you support. Another potential goal in planned giving is to take advantage of various income tax deductions that are available for charitable giving. There are also estate tax deductions if you happen to be one of the lucky people that has an estate large enough to be subject to federal estate tax. And it can also protect your assets and help ease the administration of your estates. So let me talk about a little bit of planned giving that you can do while you're still alive. Next slide, please. Next slide, please. Thank you. There are different ways to donate during your lifetime. You can make a one-time donation. That's easy. We all understand that. Or you can do a recurring donation. That might be a payroll deduction through your employer. It might be a monthly donation through your bank or credit union. That's one type of donation strategy. Another type of donation strategy that's become popular recently is bunching up your donations. Congress has raised the standard deduction to $12,400 for most individuals. That means if you itemize your deductions, and let's say your itemized deductions are $13,000, you're really only getting $600 in deductions as an additional benefit. And that's not always worth the cost and expense of all the record keeping, the time and trouble of itemizing. And one of the reasons why they keep increasing the standard deduction is to discourage us to some extent from taking some legitimate itemized deductions. So one way you can get around that is by bunching your donations together into 1 year. Let's take a hypothetical example. Let's say you have $13,000 in itemized deductions. You're a single individual, no extra deductions or credits. So you're getting roughly $600 in benefits from that. But if you could move, say, $3,000 of that into next year, or advance $3,000 of next year's deductions into this year, then you've got $16,000 in deductions, and everything over $12,400 is an additional benefit. Now, a lot of itemized deductions you can't really move around. Your bank isn't going to be happy if you only pay your mortgage every other year. Your property taxes are due every year. But charitable giving is one we have a great deal of discretion. So if you find yourself very close to the line in terms of whether you should itemize your deductions or whether you should take the standard deduction, one way to maximize the advantage is to bunch your charitable contributions into one tax year and then go low. So if you moved $3,000 of your $13,000 into next year, this year you would still get $12,400 from the standard deduction. Next year you would get $16,000. And together, that's more than your standard deduction or your itemized deductions would have been in either of the given years if you had considered that separately. Another way to do a little bit of tax planning in a current gift is by giving appreciated property. If, for example, I own stock that I bought for $1 way back when, and it's worth $100 today, there's $99 worth of gain on that stock when I sell it. And although that will be taxed at capital gains rates, and capital gains rates are somewhat lower than income tax rates, tax is tax, and it's best to avoid it. So one of the ways to avoid paying on the capital gains tax is if you've got a highly appreciated asset that you'd like to sell, and at the same time you want to make a charitable gift, make a charitable gift of that appreciated property to the charity. You didn't sell it, so you don't have to pay any capital gains on it. The charity will get the full value of the gift. And when the charity sells it, they won't pay capital gains either because they're a charity, they're tax exempt. So you get the best of both worlds. You get the full benefit of your donation and you avoid the capital gains tax that could potentially be due. An angle that doesn't come up very often, but seems to be very popular among some of the veterinarians on the EveryCat board, is that for individual retirement accounts, when you reach a certain age, you have to begin taking mandatory distributions from your retirement account. Some of those distributions are taxable, some are not taxable in a traditional IRA. So what you can do is, if you're 70 and a half, you can make a transfer from your retirement account to the charity. And just like with the gift of appreciated property, you manage to make this gift without paying the taxes that might have been due had you done it by a different arrangement. Another thing you can do during your lifetime is create what we call a life estate. A life estate is when you transfer property to another entity, but reserve to yourself the right to live there for the rest of your life. That's the traditional life estate. So if, for example, I were to deed my house to EveryCat, I would get a tax deduction today. If I reserved a life estate, I would still get a tax deduction, but it would be reduced by the amount of my life expectancy. So I could live in my house for the rest of my life, but get a tax deduction today for what essentially is going to be a donation to EveryCat when I die, because I'll have possession of the house until then. Likewise, there are different types of charitable trusts where you can do a similar arrangement, either reserving income for life from the trust or having income from the trust go to a charity and the corpus of the trust go back to you. So those are some of the lifetime planning you can do when making your gifts. But most of you are going to do most of your estate planning through estate planning. So let's talk about just some really basic, simple estate planning. What is a will? What is a trust? And why might you need both? A will is what we call a testamentary instrument. It's a document that goes into effect when you die. And can we change slides, please? You could change your will 100 times before you die. It's only the last one that you have at the time of your death that will go into effect. And what the will is a blueprint by which your executor will go to court and probate your estate. That means gather together your assets, inventory them, pay off your just debts or expenses of administration, and distribute the remainder to your heirs. There are different types of wills. The two most common are so-called witness wills, which is exactly what it sounds like. It's a will that's drawn up under the law of your state that is then witnessed by however many witnesses are required in your state, with whatever fanfare and whistles and bells are necessary to make it legal in your state. The other kind of will that people commonly do is what's called a holographic. And holographic means in your own handwriting. A will that is written entirely in your own handwriting may not need to be witnessed in most states. There's a problem with that. One of the problems is it has to be entirely in your own handwriting. So there are a few states that if you were to make the mistake of having a holographic will, you write out the will entirely in your own handwriting and think, maybe if I had a witness, it would be better. Having a witness could actually make it worse because you now have writing on the page that isn't entirely in your own handwriting. And so that could invalidate it. Other states simply ignore any additional, too far, back up, ignore any additional writing on the page if it's not germane to the subject matter. So basically what a will is, as I said, is an instruction for your executor to take to the court to gather together your assets and probate your estate. So what is a trust? A trust is a private arrangement where you transfer some of your property to the trustee, who then manages the property and distributes it according to the terms of the trust. The person creating the trust is usually called the trustor, although in some states they may call him the settlor, the grantor, the testator, depending on how the trust was created. The person who creates the trust transfers it to a trustee. The trustee then manages it for the benefit of some other party, the beneficiary. The beneficiary may be a beneficiary as to income, or they may be a beneficiary as to the corpus, the body of the trust, depending on how the trust is set up. One of the reasons to do a trust is if you transfer everything you own in the world into a trust and then you die, there's no court involved because there's nothing to probate. You didn't own anything. The trust owned all your property. So then instead of going into court and probating your estate, the trust will then proceed without you. You'll have named a successor trustee in the trust to manage the trust after you're gone. And then that person will manage the trust according to terms. That may mean retaining the trust for a period of time and paying the income to a minor beneficiary or something like that. And then over a period of time, eventually the trust will distribute the remainder, whoever are the remainder heirs. What most attorneys do when they do a trust is they do a will at the same time. And the reason you do both is because if you're going to try to pass your estate through the trust, a trust only acts on that property that you specifically place into the trust. And we're all human, and we all make mistakes. So when you're funding the trust, when you're putting the property into the trust, your lawyer will often help you with that. But then over the years that follow, you're going to buy things, you're going to sell things, you're going to open bank accounts, you're going to close bank accounts, and you're not going to always remember to put everything in the trust. So the purpose of having a will when you have the trust is a safety net, so that anything that you failed to put into the trust or that you took out of the trust and failed to return has a means of being distributed when you die. Typically, when you have a trust and you have a will to go with it, we call that will a pour over will. And the reason is because all it does is whatever assets are subject to the will, you pour them over into the trust. It's a fairly literal description. So a will is a document that you need to probate your estate. A trust is a private arrangement you do if you want to avoid probating your estate. And a pour over will is the safety net that you have with your trust in order to make sure that you didn't inadvertently leave something out of the trust or if something falls out of the trust. Okay. Having talked a little bit about probate, let's go to the next slide. Let's talk about things that you don't probate. These are things that generally don't have to go to court when you die and generally are not subject to your will. The first would be a trust. I just mentioned that one of the purposes of creating a trust is to avoid probating your estate. Life insurance generally will not be part of the probate of your estate. If I have a contract with an insurance company that says, divide this up among my 3 grandkids, it doesn't matter what my will says. The insurance company by contract has to divide it up among my 3 grandkids. So life insurance generally avoids your trust, avoids your estate unless you've named your estate as either the beneficiary or a contingent beneficiary. If it's payable to your estate, then obviously it's going to become part of your estate. IRAs, annuities, pensions, 401ks generally have a beneficiary designation. Those assets are going to go to the beneficiary you designate, not what's happening with your probate estate. Similar payable on death accounts. Oftentimes people open up what we used to call totem trusts, which are small custodial accounts for children or minors or for family members. And during your lifetime, you control the account, but when you die, the bank automatically pays it to the payable on death beneficiary. And many types of financial institutions will allow you to make accounts payable on death. Even brokerage accounts can be payable on death. Another asset that does not go through probate is joint tenancy property, which in some states they have something called tenancy by the entirety, which is a marital form of joint tenancy. Essentially, joint tenancy means that people are undivided owners of the whole. So I and my spouse may own the house together. We each own half of all of it, not all of half of it. And when one of us dies, it automatically, by operation of law, goes to the other. So it makes no difference what my will says. The surviving joint tenant will receive the joint tenancy property. So these are all assets that will pass outside of your estate under most circumstances. Okay. And then one more thing I wanted to be sure to cover. Go ahead, flip it. Probably the most common question I'm getting these days is, people say, I already have a bequest to the Wynn Foundation. What do I do now that you're EveryCat? First thing I have to say is, don't panic. You don't have to do anything right away. EveryCat is Wynn. Wynn is EveryCat. It's the same organization, just under a new name. Any bequest to Wynn is still valid. If it was valid before, it's valid now. So don't panic about making the change. However, over time, as you review your estate planning documents, as you make changes, as you update it, that's the time to start putting the new name into your documents. My personal recommendation is that you should review your estate plan at least every 3 to 5 years, because you may have had wonderful plans at the time you put it together, but things happen. People die, people get married, children are born, grandchildren are born, children get married, children have children. Your estate is going to change over time, so you ought to have it reviewed by your attorney every 3 to 5 years In addition, there are changes in the tax law that can happen at any time. If those happen, you may want to get them reviewed sooner. If there's something major that happens in your life, like you get married, you may want to get your estate plan checked sooner to take into account a change you just made. But my suggestion is leave it as WIN for now. Let it become every cat the next time you sit down with your attorney and make changes to your estate plan. Now, there was an old saying that any publicity is good publicity as long as you get my name right. At the very least, get our name right, which is Every Cat Health Foundation. Years ago, I had a lawyer I shared space with who was active in Alzheimer's, and he got involved in an estate where somebody had left some money to Alzheimer's, but had mucked up the name of the organization so badly nobody really knew what it was. I believe approximately 50 different organizations came forward claiming to be that particular organization. Now, these people had a lot of sense and settled it rather quickly so it didn't all wind up going to the lawyers. But not everybody has common sense, so make sure you get our name right at the very least, Every Cat Health Foundation. Beyond that, if you mention in the will or the trust that we're a 501c3 nonprofit corporation from District of Columbia, that helps us identify us a little further. It's nice if you have that additional information. It's nice if you also include our address. Again, that's additional information that can help identify exactly which Every Cat Health Foundation you mean. I don't think there's more than one of us out there, but again, it's a means of identification. And then one thing I recommend that a lot of other attorneys don't do, but I think they're coming around to my point of view, is including our tax ID number in the estate document. The reason to not do it, I think, is that people think of the tax ID number in a nonprofit corporation the same way they think of a social security number. And as we all know, you don't ever give out your social security number, your date of birth, your mother's maiden name, your favorite childhood pet, or the street you grew up on, because these are all bits of information people could use for identity theft. So these are all confidential things that you should keep confidential. So why shouldn't you keep Every Cat's tax ID number confidential? Well, the difference is that we're a public charity. Our books are open, our books are transparent. You can go on the Every Cat website, click on a box and get a copy of our last tax return. And it's got our tax ID number right up on the top. You can go to websites all over the internet that rate different charities and provide information on charities that have our tax return, that have our tax ID number. It's out there. There's nothing to keep secret. So the reason to keep it secret doesn't exist. So I personally see no harm in using it as an ID number. And I think that a lot of other attorneys are gradually coming around to that point of view. And that was where I have the plan talk ending. We've left a little time at the minute for questions. Vicki, do we have any questions that people want answered?
Well, let me ask Virginia. I guess I'm not getting the feed, but actually while that is happening, George, and this is wonderful information and something unfortunately my husband and I need to attend to here too. How do you go about finding the best executor, administrator, trustee? How does one go about that?
Okay, there are two ways to do it. The way I'm going to recommend and the way everybody really does it. Being an executor has, or a trustee, or an administrator, or whatever, has certain functions you have to perform. You need to be able to gather together the assets of the person who's passed on. That can be tricky these days. It used to be that everybody banked at the bank closest to them and everybody got paper statements every month. So much banking and so much financial work is done online now. It may require a little bit of detective work to gather together all the assets of the decedent. Then you have to provide an accounting for all of that information you've gathered together. Then if it's going to court, you have to provide reports to the court, and then you have to distribute it to the executor, to the heirs. So my recommendation is pick somebody with the heart and soul of an accountant, somebody that's good with books, that's good with numbers, that can dot their I's, that can cross their T's. Don't necessarily pick your best friend who can't balance a checkbook. They would be a poor choice. The skill set required for being an executor or a trustee or an administrator requires you be able to handle numbers, you be able to handle bookkeeping, you be able to deal with the law, and hopefully be able to deal with some minor legal matters that you're going to have to iron out. That's what I normally tell people. What happens in real life is people name their spouse as their first choice and their oldest child as their second choice. I'd say 90% of people doing it that way. And the reason people do it that way is because they feel that's what's expected. And if they don't do it that way, it might produce strife within the family. You know, God forbid you pick the second child over the first child as your executor. So you have to decide for yourself whether that's an important feature. And it is important to maintain peace in the family after you're gone. But my recommendation is pick the one with a head for numbers and an ability to deal with the paperwork that's going to be involved.
George, this is Virginia. I have a question for you.
Sure.
This is from one of the listeners. Can you clarify that for regular investment/brokerage accounts, i.e. not IRAs, if beneficiaries are named, these accounts do not need to be accounted for in a will?
They don't need to be accounted for in the will, but usually there's first of all, a will acts on all property that you happen to own at the time of your death that isn't otherwise disposed of. You may have an IRA or an insurance policy or something else where you've named a beneficiary. That beneficiary may predecease you. And when you run out of beneficiaries, what happens? It goes back to your estate. So at least, even if you have a beneficiary designated on those things, and it should go to the beneficiary, things could happen and it could somehow wind up back in your estate. So you should at least allow for that possibility. And at some point in your will, if you're going with a will, you should have that, you know, anything else in my estate not otherwise disposed of goes to, and we call that the residuary. The rest, residue, and remainder of my estate goes to. And that way, anything that falls into the will, because, you know, you have an insurance policy or a beneficiary designation or an IRA that failed because the beneficiary was gone, it falls into your will. You've made some provision for it.
Thank you.
Yeah, thanks, George. I'm going to ask anybody out there if you all have questions for George. Now would be a great time to put those in the chat box. Virginia and I are having a little bit of problem here between the two of us, though we'll find your questions. And if we don't have any today, you guys probably thinking, well, I need to think about this a bit, and that's fine too. We're always happy to try to answer your questions anytime just by calling the office, and we'll get the right person to contact you. If you are interested in making a donation to Every Cat Health Foundation today, in the chat box there is a little message in there about texting, and the text number is 833-985-2287, and in the text box just type in CATS in capital letters, CATS. So Virginia, do we have any more questions, or are we going to let everybody kind of go and think about this for a while?
There is a question.
All right.
And this is kind of, when you think of trusts and wills, most people think of people that have large assets, estates, etc. Normal, everyday people, middle income, what's the benefit there for them?
Well, first of all, the purpose of a will is to designate who gets your property when you die. If you don't have any property and you don't have any kids, it doesn't matter. You probably don't need a will. But if you do have children, at the very least, you can use your will to nominate guardians to take care of the children when you're gone. So even with no assets at all, you might want to have a will. But if you have any assets, then you want to have a will so the right people get the right property. And I hear people say all the time, well, if I don't have a will, they'll give it to the same people I would have given it to, and blah, blah, blah. It's more complicated than that. I happen to live in California. That's why I practice law. Who gets your property depends on what kind of property it is. For example, if it's characterized as community property, it all goes to the surviving spouse. Your kids get nothing, all to the surviving spouse. If it's deemed your separate property and you have multiple children, 1/3 goes to your spouse, 2/3 goes to your kids. If you don't have kids, half goes to your spouse, half goes to your parents. And so what sometimes happens is you'll have an estate with an asset in it, and you don't know who it's going to go to until you determine what the status of that property was. And since it makes a substantial difference where it goes, your heirs wind up fighting over whether the house was community property or whether it was still separate property from before the marriage or whatever. And you're just basically inviting litigation. So even on a relatively modest estate where you're relatively sure where it's going to go, it's a small price to pay to assure the right people get your property and to quell some of the problems that your heirs may have in administering the estate. Now, the purpose of having a trust is to avoid going to court with the estate. And the reason you want to avoid court, number one, nobody likes going to court. Nobody likes lawyers. There's filing fees, there's legal fees. It takes time. It could take months. It could take a year. Whereas with a trust, everything could be done in a matter of weeks. So people do trust to avoid the cost, the inconvenience, the time, and the hassle of a probate. It used to be that you had to be a millionaire to do a trust because it just wasn't worth it. But
Right.
given how much probate fees have risen over the years as the size of your estate, in many states, the probate fee that the attorney gets or that the executor gets is based on the size of the estate. So as inflation makes our property more and more valuable, the fees go up and up and up. And so that's why people do trusts. It used to be people did trust mostly, they were millionaires and they were trying to avoid income tax. But now just avoiding probate, avoiding the hassle and the expense of probate is the reason why most middle-class people do trusts.
Thank you. That's a good information.
Yeah, that's great information. In fact, I think it's time for me to get serious and think about a trust. Anyway, uh, do we have one more question, Virginia, or are we about ready to wrap up for today?
So one more question is, if you're middle class, not a millionaire, you want to do a trust, no kids, no spouse, you own some property. Can you just go over a quick again how we make the trust so that I can live in that house, and then when I pass, the house or the value of the house goes to whoever I designate?
Sure. There are some trusts are done while you're alive. Some trusts are created in your will when you die. What people call a living trust, an inter vivos trust, a family trust, all different names for the same thing. I create a trust during my lifetime. I am the trustor. I created the trust. I name myself as trustee. I manage the trust. I name myself as beneficiary. I get all the money from the trust. The trust is me. If you look in the IRS regulations, those are called grantor type trusts. And a grantor type trust doesn't even need its own tax ID number. It just functions under your social security number because it is you. During your lifetime, you wouldn't even know the difference. If you sign a check as trustee, it's like when you get married and remembering to sign your married name. That's all there is to being trustee of your own trust. You don't file any tax returns. You don't file any reports. You don't report it to the IRS. You simply do it. You transfer your property into the trust. Then in the trust, you will designate this person takes over when I die or become incapacitated. That will be your successor trustee. When you die, they'll file some papers transferring your property and you're done. So that's really all you need to do. The trust will be almost completely transparent while you're alive. It won't affect your lifestyle. It won't change anything you do. It will not create any additional reporting requirements. However, once you die, the trust can no longer function under your social security number because you're not there anymore. So it would have to get its own tax ID number if it's to continue in existence for any period of time after your death. So let's say you're setting it up so your trust is going to give somebody, $1,000 a month for the next 10 years. That trust would have to get a separate tax ID number because it can't use your social security number anymore. And it would mostly file an informational return as long as it passes through all of its income to the beneficiary. But for a simple living trust, inter vivos trust, I'm old, I like using the Latin. It really is transparent. You will deed the property from yourself as a human being to yourself as trustee of your trust. And from that point forward, you treat it exactly the same way you treat any other money.
That's
Thanks,
interesting.
George.
I didn't know about that at all. I didn't know anything about that at all.
Yeah, this has been a really, really informative session here today. Like I say, it's complicated, George. You've made it a little easier, I think, for me to get my hands around. Obviously, there is a lot to it, but we appreciate you taking your time to make a very, very complex subject at least somewhat understandable. And I want to thank again everybody for joining us today. And if there are any additional questions, please do contact us. We'll try to get answers back out to you all, posted on our website or however. But again, for the future, for the future of our cats, for their health, and in return for the great companionship they've given us, we hope that you all will remember Every Cat Health Foundation when you want to write a check and do some good. So again, thank you everyone. Thank you, George. Thank you, Virginia, doing our behind the scenes here. And again, you all have a great day, afternoon, morning, tomorrow, whatever it is, wherever you are. But know that we are for every cat everywhere. Thank you. Bye-bye.
Goodbye, everyone.